Good morning and welcome to the regular public meeting of the Henry County Board of Commissioners for 9 a.m. Tuesday, August the 7th, 2012. At this time, I'd like to call the meeting to order and ask for an acceptance of the agenda. Motion by Mr. Bowman and a second by Mr. Holder. All in favor? Motion carries 5-0. The first item this morning is under purchasing. We have a resolution requesting approval to extend the warranty contract for 3 Schindler elevators. Our presenter is Rod Gray, the purchasing director, exhibit number 1. Good morning.
Madam Chair, Commissioners. This item I have is a request to approve extended maintenance warranties for 3 Schindler elevators. The elevators are located at the Police Department North Precinct, the Locust Grove Event Center, and the Locust Grove Recreation Center. It's been determined that the required maintenance for these units should be completed through the sole source maintenance agreement to maintain all existing warranties and the terms of the Schindler maintenance agreement. The term of this extended maintenance agreement is for 10 years for a time period not to exceed June 30th, 2022. The cost would be $1,800 per year for the Schindler elevator at the Police North Precinct and $2,760 per year for the Locust Grove Event Center and the Locust Grove Recreation Center. Departmental funds are available to cover the monthly fees.
Okay. And I noticed in here that there is a termination clause that if we needed to terminate, we could do that by giving 90 days notice.
Yes, ma'am. And typically we wouldn't bring a 10-year agreement to you, but it's a sole source agreement. Basically, we've identified that Schindler has to maintain these units, and there's only one Schindler maintenance agreement, and that's why you're seeing a 10-year term as opposed to our typical 3-year.
Does any board member have a question or comment?
Madam Chair.
Mr. Holder?
In these numbers, I know that's an extended warranty for 10 years.
Yes, sir.
Does that cover everything, or does that cover just warranty? I know you mentioned maintenance earlier. Is it included in that?
There's covered rates for maintenance. If we have to fix something, it would be an additional cost. This is to maintain them and it's the warranty. Certain things are covered, certain things are not covered. If it's like an operator error, something of that would not be covered by the warranty. So it would be an additional cost.
Is Schindler the only company that can provide the warranty for these particular elevators?
Yes, that's why it's presented as a sole source. It's a Schindler elevator, and we still have some existing warranties on these elevators, and if we don't use Schindler repair service, then it would void the warranties. And we've also had some real issues with non-Schindler people fixing these elevators. I mean, it's been problematic, so there's that factor also.
Mr. Samey?
I have a question, Mr. Bowman. On most elevators that's used by the general public, the state requires you to do an annual inspection too, right?
That's correct.
Would this be part of
Yes.
it? This would be cover that? So we're getting something for dollar value there too?
If you'll recall, last month I brought an elevator maintenance annual contract. I pulled these out of it because of the proprietary nature of the equipment. It's basically the same thing. It's to meet the inspection, to maintain the day-to-day standards, and it sets fees for repair work, so we know what will be charged if certain events occur.
And one other question for the county attorney. LaTonya, one of the elevators at the event center actually occupies the police precinct. Could not that warranty be paid out of seized funds for that portion of that warranty?
Well, generally, seized funds can be utilized for police operations matters. And the only restriction is you can't supplant the budget for. But if it's a legitimate law enforcement related purpose, you can use those funds for that. And so that would be within the board's discretion if you want to make that determination.
Fred, could you look into that? Because I think that would save us $1,700 a year out of the general fund if we could actually pay for that out of seized funds.
I'll check into it. I don't really know.
Mr. Bowman?
In the future, we may want to consider writing Schindler out of our specs simply because of their sole source issues and the issues that they have that others can't, where you've got Cone and Montgomery and a lot of these other elevators, anybody can work on them. Schindler has their own, And, you know, it would probably something that we would want to look at in the future is to write them out of the spec, just go with ones where they're more generic, where other companies can do it. Just a comment.
That's an excellent point, and I think one that has been noted. I think we've experienced some issues with these Schindler models, and just the limited pool of resources to fix and maintain them, and I think that's an extremely valid point, and we'll make note of that. Yes, sir.
Are there any other questions or comments pertaining to this item? If not, you have before you a resolution approving the extended warranties for the 3 elevators referenced in the resolution, and I'll entertain a motion. We have a motion by Mr. Bowman and a second by Mr. Holder. All in favor?
Can I make a comment first? Do we need to put that verbiage in there that if seized funds is available and authorized to be used for the maintenance on that one precinct, could it be inserted in your motion?
I think that anytime you come back and make that adjustment, anytime in the future, if that's what you all determine, if after the county manager makes that recommendation, or you also determine that you want to amend that to make that change, you can do that. So it doesn't necessarily have to be in this particular budget approving these contracts, the funding source.
And I didn't identify a specific line item either, so I agree with the attorney. You have the flexibility to make that change. Yes, sir.
All right. Well, once again, I'm going to call all in favor of the motion. Okay, motion carries 5-0.
Thank you.
Thank you. The next item is under Public Works. We have a resolution requesting authorization to purchase an excavator and accessories. Our presenter is Butch Oliver, Stormwater Director, Exhibit Number 2. Good morning.
Good morning, Madam Chairman, Commissioners. Stormwater would like to purchase, I give each one of you a picture of the Kubota that we're talking about. And on the second page, it shows a grinder head that attaches to it. We'd like to purchase this to help clean out the detention ponds. We're currently using a skid steer with a grinder on it. And on those slopes, we've turned that skid steer over several times. And this will be a lot safer and a lot more easier to clean those slopes out. We purchased them, went out 2 bids. Our local vendor won it. So if you got any questions?
Will this speed up, I guess, the
Yes,
cleaning
ma'am.
of the detention ponds?
Yes, ma'am, quite a bit, because right now, we're having to cut the trees down with a chainsaw, drag them out, and then the skid steer runs over top of it. It has a grinder head, and you run over top of it, and that's where we flip the skid steer a few times, because it'll slide off the trees and it'll turn over on its side. This way, grinder head, we can start on the top of the tree and we can grind it down. Now, we can't cut big trees up with it, but normal-sized trees in detention ponds, yeah, so.
And you have someone in Stormwater that's able to operate this type of equipment?
Yes, ma'am.
Mr. Bowman?
I just have a question for the county attorney. I bought several large pieces of equipment from this company. I don't see how that would be a conflict, but I just want to be sure that it's not.
No, that would not rise to a level of a conflict.
All right, thank you.
Any other questions or comments? Mr. Stamey?
Does this come with any type of maintenance agreement or warranty? Do you know?
Did it come with 1 year, Rod?
I do not know that answer, but I can get that answer. I mean, we did not ask for that information. It's going to come with whatever comes with the equipment, sir.
I think it normally comes with a year, but we can find out and make sure.
There's a factory warranty that comes with all of that.
Right.
Madam Chair?
Yes.
I just also wanted to note for the record that the Henry First Initiative applied in this situation. The vendor complied with all the terms, and I just thought that the board would like to be notified that some of the policy they've enacted is working actively, and it worked, and the local vendor met all the terms, and through the Henry First Initiative, they were awarded this project.
Thank you for sharing that.
Yes, ma'am.
Any other questions or comments pertaining to this item? All right, if not, you have before you a resolution approving the purchase of this Kubota extractor and accessories for the Stormwater Department, and I will entertain a motion. Motion by Mr. Holder, second by Mr. Bowman. All in favor? Motion carries 5-0.
Thank you.
Thank you. The next item is a resolution requesting approval for monitoring services at the West Asbury landfill. Our presenter is Terry McMickle, Public Works Division Director, Exhibit Number 3. Good morning.
Good morning, Madam Chair, board members. We're seeking approval for a purchase order for semi-annual detection, groundwater, and surface water monitoring and reporting services at the West Asbury landfill. The purchase order amount would be for $15,850. And we had budgeted those funds in the solid waste fund.
How long has that landfill been closed?
It's a guess, I'm not sure. I'm going to say it's been closed at least 25 years. Warren, is that?
You're close. And again, every one of us get complaints about not having a, quote, landfill, even though we do have a recycling center now that's better than it's been in years. This goes to show you, just as a cost to every taxpayer, what it costs just for the monitoring after this landfill has been shut down for 25 years. So a landfill is a very expensive, whatever you want to call it. It's just very expensive to maintain, to operate, and of course, in this one, after closing, you see what it's costing each year just to monitor it, so that we're sure that no methane or whatever's getting out and it's leaching into the water system and what have you. So it is an expensive process.
And this is just for the professional guys to go out and monitor it. That's not maintaining that SVE system. It's not cutting the grass on it. It's not maintaining around it. I think the combined budget for both of the Windy Hill and West Asbury is like $45,000 a year, just to to do what we're supposed to do with those landfills.
It's expensive.
Is there any, and I guess it varies with different landfills, any light at the end of the tunnel? At what point will the county not be required to do this type of monitoring?
At some point in time, these landfills supposedly have a life, that they quit generating methane. Usually, I've been told, and I'm by far no expert on landfills, I assure you, but usually in the 25-year range, they start going the other way. They start generating less. We haven't experienced that yet at either Windy Hill or West Asbury, but I've been told they do at some point in time go the other way. So I think there is. I just don't know how far that light is out.
When we get ready to move forward with the McDonough Parkway extension out here, which will come in on Highway 20 right there at the BP gas station, are we going to have issues with taking that roadway through and near this landfill? Is that some of the holdup too in moving forward with that project?
It's a big part of the holdup on that project, because as soon as we come up the hill from the admin building, you go directly across that landfill, and that's really a different segment. That particular landfill is not being monitored. It was closed before those requirements came about. And there's a lot of concern that if we go in there and we touch that landfill, once you touch it and open it up, and we've kind of done a lot of studying to find out what's the best way to either cross it, compact it, bridge it, or just dig it up. Looked at a bunch of options as to coming through there, but either way, I'm concerned that if we ever do anything to it, they're going to start us monitoring on it, see what's going on. So it's almost like a catch-22. You don't know which way to go with it, but it will be a cost, I assure you, and that is a major problem with finishing that segment. Very costly.
But you are still moving forward with determining the best way in which to do that.
Yes, we've done that analysis, and I think my personal opinion after all that is to dig it up. Seems to be the best way. where you don't have any future problems. To do that, though, we run some numbers, and that's real expensive. You could bridge over it. By the time you do that, you're going to spend the same amount of money, and you still have the landfill there. So it's a doable thing. It's just, right now, it's a money issue. So, in the future projects and development of projects list and things like that, I'm sure we'll look at that segment of that project.
Thank you. Does any board member have further question or comment about this item? If not, you have before you a resolution approving the purchase order for the monitoring services at the West Asbury landfill, and I'll entertain a motion. Motion to approve by Mr. Holder. Is there a second? Second by Mr. Holmes. All in favor? Motion carries 5-0. The next item is a resolution requesting an amendment to Resolution 12-118 regarding the resurfacing of Cohen Road and Old Jackson Road. That's Exhibit number 4.
This resolution will correct a former resolution, the 12-118, wherein it described the resurfacing limits of Old Jackson Road from Butts County line to Peaksville Road. This resolution will correct that and make those limits proper, which will go on Old Jackson Road from State Route 81 to the Butts County line. So this is just one of those things that didn't get wrote correctly, and we wanted to make sure that we had it correct. So this is a resolution to make that correction. Doesn't change the monies, and all that was correct. Just a description of the project limits.
Does any board member have a question or comment?
Comment, Madam Chair.
Mr. Holder?
When will the LMIG funds be available for this, to complete this project?
Commissioner, it's hard to say exactly when. We have been checking on them, and a couple of weeks ago it was about a month, so I would anticipate within the next 2 to 3 weeks we should have that money to come back and finish a portion of that road. The reason Commissioner's asking that question, a part of Old Jackson, the paving of it will be done through GDOT funds, and we can't start that until we get that contract. So what it'll appear out there is that we've completed a portion of it. The portion that we've completed is being solely paid out of SPLOST 3 funds, I guess. The remaining part, a portion of it will be paid LMIG. They don't pay all of it, but they'll pay a portion. So as soon as we get that, we'll come back and complete the remainder, as well as put another lift on Cohen as well.
And not, for those that might be watching and wondering why the paving or the topping stopped at South Ola in Old Jackson at Philippi Church, this is the reason for this, because we wanted to stop it at a major intersection, because the GDOT funds that we're receiving on this road will actually pave from Peaksville to the county line, which is what, 2,000 feet at the most?
Yeah, about that.
About
Close
2,000
half a
feet.
mile.
So we're holding that project up from that section of Old Jackson from South Ola at Philippi Church to the county line to get state funding for about 2,500 feet. The road has been resurfaced as far as the base is concerned, but the people need to know that there will be another topping on it, and then also at that same time, as Mr. McMichael indicated, Cohen will get its final lift also. So I don't want anybody to think that we've overlooked anybody in that particular project. That's not it. It's a funding issue, and I wanted to make that clear.
And I know that's kind of very disruptive for the public, but I'd have to say in our budget, as tight as it is now, we're roughly getting about around $1 million from the state. And, it's just hard to turn down that money. And when they give it to us a piece over here and a piece over here, we still take it that way because we're glad to get everything we can get.
Any other questions or comments? Okay, if not, we have before you a resolution making the correction to Resolution 12-118. And Mr. Holder, since this is in your district, I'll look to you for a motion.
Move to approve.
Okay, we have a motion by Mr. Holder and a second by Mr. Bowman. All in favor? Motion carries 5-0. Thank you. Moving on to SPLOST, we have a resolution requesting approval of a proposal for professional engineering services for the design of Frog Road. Our presenter is Rocky Romero, SPLOST Transportation Project Director, handout number 1. Good morning.
Morning, Madam Chair and board members. Frog Road is a designated SPLOST 3 transportation project. A request for proposals for professional engineering services was solicited for the design of Frog Road from the end of pavement to Lester Mill Road. Frog Road is approximately 1.2 miles long. 3 requests for proposals for professional engineering service were received and reviewed. Staff recommends approval of an agreement for professional engineering services from Falcon Design Consultants in the amount of $70,320 for the design of Frog Road. In addition, Henry County DOT will be performing the survey and right-of-way plats for a cost of $29,180. Funding for professional service is available in the project budget.
Does any board member have a question or comment?
I do, Madam Chair.
Mr. Holder?
Several meetings ago, we saw these 2 roads, Lester Mill and Frog Road, be not designated. They were already designated 3 projects, but were funded for paving. And I'm assuming Lester Mill will come later.
Already, we brought Lester Mill.
I'm sorry, that was the first year because we had a problem on Frog. Okay. But I want the people to know where the funding for those 2 roads came from. The District 1 set aside $4 million in SPLOST 3 for the improvements of Bill Gardner Parkway. $4 million wouldn't get very far, and District 2 had set aside $2 million, and their $2 million had already been taken away. So there was only $4 million left in from District 1 for the Bill Gardner Parkway. Bill Gardner Parkway was an identified project in the recent T-SPLOST, the transportation SPLOST. It was defeated this week, or last week. But I thought it was in the best interest, since it was not enough to do any it probably wouldn't even do the design for what we're talking about on Bill Gardner, but was to move those funds, and I moved them to an area, for those that are not familiar with Frog and Lester Mill. Lester Mill Road intersects Bill Gardner Parkway. So those funds, even though they're not on Bill Gardner, they're going to be in the area where those funds were originally designated to be. So, again, just wanted to give you some background as to the reasoning why these 2 roads are being chosen for paving. And also, back many, many years ago, Commissioner Shackelford, who was the Georgia DOT Commissioner at that time, wanted to assist Henry County in making Lester Mill Road a parallel road to I-75 in case of an emergency situation, which would allow motorists to exit 212, go to Griffin, go to Jackson, go wherever, if there was a spill. And we know how many truck accidents, for whatever the reason, happened just south of Locust Grove, or the 212 exit. So anyhow, that never worked out because the county at the time didn't have the matching funds to participate with the state. So hopefully this will allow that connection that will connect Locust Grove Griffin Road and Bill Gardner Parkway to provide an alternate route for the motorists. So that is the reasoning behind the movement of these funds to those 2 roads. And I wanted to share that with the people because I think they need to know.
Well, many of these projects take multiple years to get accomplished, and in reference to this one, I want to, if I'm remembering correctly, I think it's somewhere in the neighborhood of about $48 million to do what needs to be done to Bill Gardner from I-75 to 155, and I know Commissioner Bowman can relate to this because Eagles Landing Parkway, that extension that was just completed to 42 Highway was had a pretty hefty price tag as well. So the $4 million, as you said, won't go very far in a project that's a $48 million project. But many times we begin processes, and it's multiple years, and it's bringing in federal and state dollars, and then it's the local SPLOST programs that will help fund these ultimately, but it just takes a little bit of time, and sometimes it's done in phases, as Eagles Landing Parkway was done on the east and west side of I-75, actually in 3 phases. So it's transportation projects are not inexpensive, so just wanted to mention that as well. If there's no further questions or comments pertaining to this item, there is a resolution to approve the proposal for the professional engineering services for the design of Frog Road, and Commissioner Holder, I'll look to you for a motion.
I can't move to approve.
Have a motion and a second by Mr. Bowman. All in favor? Motion carries 5-0.
Thank you.
Thank you. Moving on to Planning and Zoning Services, we have a public hearing for the purpose of approving a resolution to transmit the short-term work program and capital improvement element annual update 2012 through 2016 to the Atlanta Regional Commission. Our presenter is Sherry Hobson Matthews, Director of Planning and Zoning, and it's Exhibit Number 5. Good morning.
Good morning, Madam Chair and board members. The request before you this morning is a transmittal resolution that has to be sent to the Atlanta Regional Commission and reviewed by the Department of Community Affairs. As you all are aware, in order for us to maintain our qualified local government status, which is part of the Georgia Planning Act, each local jurisdiction has to submit a list of projects that we think that we will accomplish within the next 5 years. The period that we're reviewing at this time is 2012 through 2016. If you all will note, there are a number of projects within the table that you all have received that have either been completed or postponed, but staff has gone through each one of those items and provided some type of status update on the reason why that project has not proceeded. The planning staff did work with various departments in order to gather the information, and should you have any questions regarding it, I'll be more than happy to try to answer it for you.
Does any board member have a question or comment pertaining to this item?
Madam Chair, I just comment. Ms. Matthews, this plan will be more accurate than the Ross plan from a few years ago. Is that correct?
I would surely hope so.
Okay, just wondered.
Any other questions or comments? And if I'm reading this correctly, there is going to be a public meeting in order to review this as well.
Well, we will have to have the public hearing today for it. Yes, ma'am.
Okay, so this is the public hearing.
Yes, ma'am.
Okay. Well, at this time, then, I will ask if there's anyone in the public who wishes to speak in reference to the short-term work program and capital improvement element annual update transmittal. And that's a lot. But we do this every year, and as you said, it's required under the Georgia Planning Act, and DCA requires it to be done. So if there are no comments, I will turn to the board, and you have a resolution before you approving the transmittal, and I'll look to you for a motion. Have a motion by Mr. Bowman. Is there a second? Second by Mr. Stamey. All in favor? Motion carries 5-0.
Thank you.
The next item on the agenda is also a public hearing, and this is the Henry County Board of Commissioners of McDonough request a modification to a zoning condition for property located at 2500 Highway 155, land lots 239 and 242 of the 2nd District. The property contains 231 plus or minus acres, and the request is to modify a zoning condition pertaining to the location of truck parking. Our presenter is Michael Harris, Planning and Zoning Services Division Director, Exhibit Number 6. Good morning.
Good morning, Madam Chair. Good morning, board members. Back in May of 2002, the subject property, consisting of over 231 acres, was rezoned from RA to M1 light manufacturing. At that time, it was rezoned with 7 conditions. Condition number 7, back in the 2002 rezoning, stated that truck parking will not be within 300 feet of the property line adjoining existing residential property. Subsequent to that, in 2003, that following year, a modification came in for the same property to modify a condition related to the buffers and the lighting. However, at that same meeting, further clarification was made concerning that original item number 7 regarding the truck parking. The clarification was, in essence, stated that truck parking would only be allowed, no truck parking would be within 300 feet of the Wycliffe subdivision. The clarification was given, however, was not made a part of the formal modification. Staff feels at this time be appropriate to move forward just to clarify this particular issue and make it a part of the formal modification, since that appeared to be the intent of the board at the time. So all I'm asking for today is a modification to take into account that clarification issue concerning the location of the truck parking on this site. And so it would change, so the proposed change would be condition number 7 would now read, truck parking will not be within 300 feet of the property line adjoining the existing Wycliffe subdivision, as was noted in the intention during the modification hearing of 2003.
Does any board member have a question or comment? Mr. Preston?
I was just going to comment that I really appreciate Commissioner Holder, as well as working with you, Michael. I mean, because there was a lot of communication between the homeowners over at Wycliffe, and Commissioner Holder was very helpful as kind of bringing back to the thought process of back when the board was hearing this back in 2002 and 2003. So appreciate your work as well.
Mr. Holder, you had a comment?
Yeah, Michael, Mr. Nutt, who is the property owner that's on the south side that's referred to in the March 17th, 2003 minutes, what's the latest response from him? I spoke to him early on, but I've not spoken to him since. Brian, have you spoken to him?
Not since, we were all involved with those phone calls.
We have.
And I know Michael has spoken to him since that
Yes, sir,
time.
we have. We've spoken with him, and we've met with him on a couple occasions. In fact, he was in last week. We met with himself and a number of members of his family members as well to discuss potential future uses for their property. And right now, they're actually going through the process of potentially going through the process of a future land use map amendment for their property. So we're walking them through that process now. They've met with myself, with Sherry, and some of the planning and zoning staff to go through that process. And they're well aware of what's being proposed today as well, and they're made aware of this item.
Well, let me clarify this for the record. Back at that time, and when it was first brought back to me, this was from '02, so that's been 10 years ago. I did not, I remember the zoning, and of course got the minutes pulled and saw what was said. And the amendment to the motion from '03, I honestly did not remember specifically the comments that I made. Then when they were pulled, and I've read, and I will certainly read it to the people right now, and my position today is the same as it was in '03. And I said, Commissioner Holder explained his intent when the original motion was made establishing conditions on the development. The Wycliffe subdivision was the only resident on that side that actually adjoins the property, and that is correct, and it's still that today. And that's on the back side. On the south boundary, which is the Nutt property, it's open field, which I think most likely with industrial development down Highway 155, you will not see any more residential beside this particular piece of property. I still say that that's what will happen. I don't think you'll see residential development behind the McDonald's and the Publix and the bank and the various strips, the strip development along that road. But I just wanted to clarify it. I actually had forgotten that I made that statement, but I stand by that statement today as I did 10 years ago, or 9 years ago, or whatever.
Any other questions or comments? If not, this is a public hearing, so I'd like to ask if there's anyone in the audience who wishes to speak either for or against the modification. Yes, sir, if you could step to the microphone and state your name and address for the record. Good morning.
Good morning. I'm Jose Cortona, and I live behind what they're doing right now. And 300 feet, whatever they're doing right now, I mean, my house is still it shakes every day with the construction. The noise is terrible. So I think 300 feet, I mean, they should have more. They're making this big, like a mountain that's safe for the noise and the lights. And I don't think it's not going to help us in anything. I mean, we still hear noise. Like I said, my house shakes now. I got cracks on the walls, and they should put something, they should be more feathered than 300 feet, you know, instead of 300. I mean, they should also put like some kind of a wall or something, those soundproof walls or something like that, instead of what they're doing right now. I mean, it's good what they're doing right now, but reinforcing would be better.
Thank you for your comments.
Thank you.
Is there anyone else in the audience who wishes to speak in regards to this modification request? Okay, Mr. Preston?
I know when I've talked to Bert Foster over, there was a contact number that we were providing to residents if there was concerns about anything with the construction too, to make sure that the buffers were staying intact and other things. Has that been made available to residents?
I'm not sure that it has been, but certainly our Development Plan Review Department, Mr. George Patterson, can address. And I know I've met with several residents out there already. We've had conversations with the superintendent out there. We're out there every day. Our inspectors are out there every day. And just a couple quick points I want to make sure I address. The gentleman's right. There is a berm that's being constructed adjacent to between the site and the residential property, and that will subsequently also be landscaped to continue to help with some of the sound mitigation as well. 300 feet parking is a 300-foot parking buffer in essence. We're prohibiting any truck parking within that distance, and we've gone, in this case, it goes beyond what our current code requires, but we felt it was appropriate to be that with the residential areas there. So we'll continue to work with residents to ensure that we can do all we can to make sure we mitigate any impact on the adjacent residents. And again, I'd be happy to share with the gentleman the phone numbers with our Development Plan Review Department. Mr. Patterson.
Yes, sir.
I'm sorry, you would have to come back to the
up.
microphone.
About the noise that he's saying, I went and talked to a supervisor over there in the construction, and he's stating that I had to make a letter, and I wrote a letter to the company. It's been about 3 weeks already, no answer. Nobody had called me, nobody had come to my house and told me, my house is all dirty and everything also because of the dust. And, I sent a letter, nobody had come to me. They send a letter, I sent already one letter, and then the fax one to them. Nobody had called me.
Okay.
Can you give Michael your contact information, and we'll make sure that someone follows up with you
Sure.
on this issue, because that's important that we do that. I can't speak for the company. I don't know why they didn't respond, but Michael will make sure that your concerns are put before the correct
Yeah, remember, this
person.
place is going to be there 24/7. So right now, every morning at 7 o'clock in the morning, 6 o'clock in the morning, I have to get up because the noise is so terrible. I haven't been able to sleep the way I used to sleep.
Right.
Yeah, well, they have some constraints on when they're able to operate, and I know regarding the dust control, there have been instances where they had to go back in and actually clean some individuals' homes. So if that's an issue, we can certainly work with you and work with the developer as well.
Okay.
Thank you.
Thank you. Michael, one other thing, too, I want to mention, and that goes to the lighting. We had some issues at Simpson Mill subdivision with the development that backs up to them on Highway 20. And, of course, that lies within the city of McDonough, but for many years we had gotten complaints about the lighting issue there. And I know we have a lighting ordinance, but I've just encouraged the staff to look very, very closely at whatever lighting is approved for that site, because we need to make sure that we protect the residents in that area from excessive lighting.
Okay. And we do. We have the most recently passed lighting ordinance does have a photometric plan is required, and they have to actually take readings at the property line to ensure that they're not bleeding over to light pollution.
Okay, but
So we'll double check that.
Please, please, please follow that closely. Mr. Holder?
One last comment. If any of you looked at the minutes from that zoning and also on the modification, you'll notice that I made the motion in '02 to approve the rezoning. In '03, Commissioner Friedman moved to approve the modification. The reason for that was in '02, that was District 1 because of the census, because that was District 1. And when the census changed it into '03, it was District 2, just like the district lines have changed now that will take place in 13. So it's a 10-year cycle, and I wanted to show you that that's the reasoning behind that, because that commissioner from that district made the motion at the time.
Any other questions or comments? All right, if not, you have before you a resolution approving the modification to the zoning condition regarding truck parking for property located at 500 Highway 155 South. And Mr. Preston, this lies in your district, and I'll look to you for a motion.
Make a motion to move to approve.
Okay, we have a motion to approve. Is there a second? Second by Mr. Holmes. All in favor? Motion carries 5-0. Thank you. The next item on the agenda is a discussion regarding personal care homes. Our presenter is Sherry Hobson Matthews, and that's handout number 2. Good morning.
Good morning, Madam Chair and board members. This morning, I wanted to have a discussion with the board regarding the moratorium which was enacted by the board on March 20th of this year. If you all will recall, we did enact a moratorium, or the board did enact a moratorium, which was a 90-day moratorium barring the acceptance of any applications for personal care homes, any zoning applications, any business license applications, and any development permits for anyone wanting to operate a personal care home. The moratorium was enacted for various reasons, but most notably to give staff an opportunity to go back and review the intentions that the board placed for personal care homes during the adoption of the Unified Land Development Code, and also for staff to look at some of the terminology that was currently in the Code of Ordinances that may not have had definitions or really made a lot of sense on what we really wanted to do with personal care homes. We also reviewed other jurisdictions to see if we were consistent with those jurisdictions and to see if we were in line with some of the regulations that other jurisdictions had in place. So on May 15th, staff came back before the Board of Commissioners with a long list of suggested recommendations and amendments to that ordinance. At that time, there were a number of individuals that were present for the meeting, some in support of the recommendations presented by staff, and the number in opposition to what staff is recommending. As a result, the board directed staff to have a town hall meeting to see if we could come to some type of consensus on a amendment or on some regulations that would maybe make everyone happy. So on June 28th, there was a town hall meeting that was held here at the County Administration Building. There were probably over 100 individuals that were present for the meeting, and the meeting had a lot of information that was offered to staff. One thing that was recurring, and one recurring theme that staff continuously heard throughout that meeting from both sides, was the rights of the property owners and then the rights of the individuals who were going to reside within those personal care homes. What I've included in your package is a draft summary of the minutes based on some of the comments that we received during the meeting, so that you all have an opportunity to kind of look through the comments that were received. As a result of that meeting, staff felt that it was pertinent to have another meeting, but to try to scale that meeting down to a smaller group of individuals. So on July 12th, staff met with some of the property owners and some of the individuals who had spoke in opposition or not in support of the staff recommendation. And during that meeting, we again tried to come to some type of consensus based on the original recommendations by staff. After a lengthy discussion, we came up with a set of what we felt were some good modifications, but it still didn't make the mark for a number of individuals, and most notably, we still had not addressed the reoccurring theme that we continuously heard, which was the Fair Housing Act. So what we did is went back, decided, let's go back, let's take a look at the Fair Housing Act, let's make sure that we aren't missing anything, and let's make sure that whatever we present, that it is a legal document that we can feel comfortable and stand behind. So what you have today in front of you is a list of recommendations that staff, particularly with the assistance of our county attorney, felt that would be beneficial not only to the county, but would keep with the regulations that are set forth in our Fair Housing Act, or in the Federal Fair Housing Act amendments of 1998. I will place on the overhead the latest and greatest recommendations that are being offered by staff. Again, as you all are aware, currently the Code of Ordinances would allow a personal care home in any residential zoning district with up to 3 individuals as a home occupation. The Unified Land Development Code also referenced a non-home occupation personal care home, but there was no terminology for that word. There was no definitions provided anywhere, and in checking with other jurisdictions, that terminology just did not exist. So what we are presenting to you all today for discussion purposes only is a list of new recommendations that we would hope that we could have some discussion on and staff could get some guidance on next steps. The first one is a home occupation business license shall be required for all personal care homes up to 6. The number 6 would be consistent with what our requirements for any other home occupation within our county code. A daycare facility, an adult daycare facility, the magic number is 6. All home occupation personal care homes shall be again limited to 6 persons in accordance with state requirements and consistency with other allowable home occupation uses. Number 3, personal care homes shall be allowable in all residential zoning districts. Number 4, all personal care homes with more than 6 persons shall require and obtain a conditional use approval. Number 5, non-home occupation shall be removed and deleted in its entirety from the Unified Land Development Code, again, because there is no terminology in the Unified Land Development Code or in the American Planning Association Planner's Dictionary. Number 6, personal care home definition should be amended and be in line with the state of Georgia's code, the state of Georgia's definition that's provided by the state, so that we will have a consistent definition. And I will include that definition on the overhead in a second. And then finally, we will add personal services definition to the current Unified Land Development Code, and again, and that is in keeping with the state of Georgia's code and their definition. What staff wants to do today is get some direction again from the board, if we're in the right direction, if we need to go back to the drawing board. But most importantly, 2 things need to happen today. I will be asking the board to extend the moratorium because it will expire on August the 13th. And I would hope that we could extend it to a date specific. We have advertised already for the August 21st meeting to have this item heard so that we can move it. But if the board elects to extend it beyond that, please just make me aware of that, and I'll make sure we can get that re-advertised. And then lastly, just need some direction from the board on whether we need to go back, revisit some of the information that we've presented, and just kind of go from there. And I hope I haven't omitted anything, but if I have, please feel free to ask.
Does any board member have a question or comment for Sherry?
Madam Chair.
Mr. Holder?
On number 4, what is the magic in the number 6?
6 has been in the current county code since I've been here with the county. I think 6 has just been the number for our daycare facilities, for adult daycare facilities. That's just the number that we typically use in home occupations. I don't think there is any magic to it. I think that's just a random number.
It's not part of state law or a requirement or anything?
No, sir, not that I'm aware of. But what we wanted to make sure, in keeping with our interpretation of the federal law, is that we have to be consistent with what we already have on the books. So, for example, if we had a home occupation, or in our home occupation ordinance, if we allowed as a daycare facility up to 10 children, our personal care home ordinance needs to be up to 10. If we allow up to 4, then our personal care home ordinance needs to be up to 4.
Mr. Bowman? Oh, I'm sorry, Mr. Holder.
One of them. As far as federal housing rules, where do we stand as far as complying with the federal housing?
I certainly think, and I will speak and then I'll defer to the attorney if she wants to offer any additional comments. The original recommendation that was being presented by staff, we had some differences in making a difference between a personal care home being allowed within a subdivision and outside of a subdivision. And I think the Fair Housing Act is very clear in that while we can have regulations in our ordinance, we can't make it where it's not reasonably easy for everyone to have the same processes. We can't make a difference between one particular use and not make a difference between the other use. This item did go through the review process, and our county attorney did review it, but I certainly don't want to try to speak on her behalf on that part.
You did a great job summarizing it. Commissioner Holder, you, from the beginning, have said these are businesses. I mean, that has been, and you're right, at the end of the day, most of these homes are being operated for profit and operating within the residential zoning districts. So when we look back and went back to look at attempting to impose reasonable regulations, which the county is allowed to do under zoning land use regulations, and balance that against the interest of treating all individuals as similarly as we can in our regulations, looking at these uses as business uses in residential areas was the most neutral approach that we felt we should undertake. And so the board certainly has the right to regulate the manner and method in which businesses are run in single-family dwellings neighborhoods. And I think that's the approach that we were trying to take here.
And this is an issue that you can argue either way.
Yes.
You can argue the fact that any property that's for rent is for profit.
That's true.
And you could argue that way, as well as saying, any personal care home is a business for profit. So it can be argued either way, and I'm sure somewhere there's a fine line that will separate the two. I don't know where that line is, but I'm just saying it could be argued either way.
It can.
Okay.
Mr. Bowman?
I have several comments because I went through and I read all the information that we were provided, and and mine's going to fall under the covenants section. One, and I'm not mentioning anybody's name, but one doesn't like homeowners associations making decisions. Well, I mean, I've been in places where if they didn't make decisions, you might have pink houses and green houses. I mean, there's something to that. Another one says covenants are only good for 10 years. Does that mean I can, that I can buy me a half dozen dump trucks and go in there and decide I'm going to run a dump truck business? Then I look at another one. Homeowners associations should not be allowed to discriminate. I don't see how it is discriminating when you in fact buy in there knowing that you have covenants. You have covenants that you have to go by. I want to just keep going. Bear with me for a minute. Covenant enforcement is not a county function. Well, if it's not a county function, then what is it? I mean, really, the people that buy in there first, and they buy knowing that there is a covenant that says that you can do A, B, C, then why should it be busted, and come back and say, well, I'm sorry, you can't do A, B, C anymore. Then you come back and it says, there's another one, covenants should be decided in court, not administratively. Well, if they are decided in court, it should be the person that's trying to bust it, not the homeowners association that put it in at the very beginning. Because they put it in, it was put in and it's recorded. It's a document. It's on the deed. I'm not, most of the things on this list I'm okay with, but when it comes down to the fact that, the covenants, if they're recorded and they're done legally, I believe that the people have a right to know what's coming in. They bought in there knowing what the covenants were, much like this one situation where the guy says it wasn't, and it obviously is, and that therein lies the problem. And why should we put it on the ones that bought first and adhered to the covenants? Why should we make them pay the legal fees to fight something that's recorded? So I have an issue with not having the covenants involved in this. I mean, there's plenty of neighborhoods that don't have covenants. But if you've got them and you bought in there first and you've been there for a long time, and now all of a sudden, and I know this is a heart-wrenching issue in that when you've got this situation, sure you want to be able to do something, but What about the rights of the others? I mean, it goes both ways. It does not go just one way. So the covenants, you know, they're recorded, they're part of the deed, and I mean, I can't, it needs to be in here so that we protect those, not from only one thing, that if you want to bust the covenants, the one that wants to bust them, let them bear the cost of the legal fees, not the homeowners association that recorded it in the very beginning. So there would be where my problem would be. Thank you.
Mr. Holder?
I'd like to address this question to the attorney. You have private covenants, and every covenants in these subdivisions are private. And you, as you said, you know when you buy in what your requirements are and what you can and cannot do, and what's allowable and not allowable. My question to you is, again, getting back to that line that we're trying to find, if there was a state statute, a county ordinance, or a federal law as far as housing is concerned, and the private covenants was in conflict with any of those, who would prevail?
The covenants run with the land and impose restrictions or limitations on the use of property for a certain activity. So it's my opinion that the covenants will prevail, that the county, neither the county nor the state could issue a license for a particular activity that will be in conflict with the covenant. Then the word conflict will be it's $1 million question. Is it in conflict or is it not? And then you have the issue of whether or not the covenants are still valid such that they can be enforced. And then you have the ultimate issue of who has standing to enforce those covenants. And the standing exists as between the residents who live in that neighborhood who will be affected by the improper use attempting to be utilized by one of their neighbors. And so it does become a matter of a private dispute that does have implications beyond, as Commissioner Bowman just specified. And I was taking notes because as we go and revamp and go back and try to tighten this up to bring the final document to you all, we need to look at that across the board so that someone has a beauty salon, home occupation in their neighborhood. You know, are there covenants that will prohibit that type of activity? And what does the county do, or what can we do to get business license applicants or any other type of applicants to demonstrate that there are no conflicting covenants? And what kind of burden would that impose on staff in reviewing it, and how much does that involve the county in a matter that could ultimately be just a private matter? So we'll consider all of those policy decisions to aid you all in making a final determination. But it will take more inquiry than what we presently require of applicants.
But just because a covenant is private does not mean that it cannot prevail in a court of law.
That's
when
correct.
it comes to a federal law. Is that correct?
That's correct. That's correct.
Okay.
One thing, you made a comment, LaTanya, you said like a beauty shop that's a home occupation, but does that person own or rent or live in the home that's doing it, as opposed to a home business where you're bringing people from outside to run something like that, like home occupations? I know we've talked about attorneys and real estate agents that have an office in their home. I don't think those are apples and oranges. I think those are apples and oranges and not apples and apples, because now you've brought in paid professionals, hopefully, to look after these situations where they're no longer a home occupation because it's not their home.
Well, some personal care homes, a great deal of them, have owner residence where the owner of the home actually serves in the capacity of the caretaker of the residence. And then you have those that hire out 24 care, and the owner of the home actually lives somewhere else, and they're leasing their home or allowing their home to be used and just ensuring that they have an administrator around the clock. So you do have those instances where if I want to use my home as a personal care home, that I can reside there 24 hours a day, and I can be an owner/caretaker of the residence.
Okay, thank you.
Are there any other questions or comments for Sherry or Michael? Okay. This is not technically a public hearing, but I know we had a number of people who signed up to speak in reference to this because this is a non-action item for today. This will be advertised for a future meeting for some action to be taken. We're going to go ahead and quickly take these public comments. And the first one that I will recognize is Gene Bouts of 341 Mountain Brook, McDonough. Good morning, and we'll give you 5 minutes.
Okay, thank you. Appreciate you addressing this some more. I've continued to be surprised at this whole situation that we've seemed to have gotten ourselves into. I'll try to be brief and address some of the things that have been brought up here by staff and by Mr. Holder and Mr. Bowman. The attorney has looked at fair housing. American Disabilities Act is also part of this picture. And to consolidate thousands of pages of American Disabilities Act into a sentence or two, it requires reasonable accommodation beyond what would be normal. And so I think that's part of this picture that would also need to be considered. On the topic of home occupations, I don't have a problem with home occupations. Our current code is allowing home occupations in any residential area with 3 clients. However, the problem with doing that across the board is that home occupations are allowing only residents that live in the home to work in the home. It does not allow for outside help, except in the situation that you created almost 2 years ago where you allowed a home occupation outside a subdivision in RA to hire 2. Mr. Holder has asked about the magic number 6. I believe that comes from the state definition and licensing that the state licensed 2 to 6. And in fact, I'm understanding that the state is trying to stay away from 6 and go to 4, being that, and my thinking on that is that that's probably more of a home-like atmosphere, and we've been trying for decades to get our special needs people out of institutions and into home settings, which we seem to not be doing as a state or community very well. Let's see. On the business topic, I think that we need to be realistic here about what's happening in our community. Think about where you live, as I think about where I live. How many of the areas we live in have someone operating a business out of an extra room, a garage, or the trunk of their car? I know that there are many of those around, and unless they're a problem, they're not too obvious, or even if they're a little obvious, we tend to really ignore those. Personal care home is no more business than any of those or what our own homes would be. I think the main thing I'm getting from today's conversation, other than the covenant situation, is that there needs to be at least some staff that is available to go into a home. I say leave the code the way it is, bring in some of the ordinance features that would help in regulating a home. We need to stay away from conditional use permit, covenants, the owner, full-time residence. We need to be able to have something that is reasonable, that fits in with Fair Housing and American Disabilities Act. I appreciate your time and consideration, and please think carefully and do the right thing. Thank you.
Thank you. The next person that signed up for public comment is Brian Bouts of 341 Mountain Brook Court, McDonough. Either one. Good morning.
They both work. A couple of just brief comments, and then one thing in particular, is particularly Mr. Bowman's concern about covenants. The first one is, in your ULDC, you have I forget the subsection, but a set of definitions. And one of them is subdivision. And I think the term, when it gets used, is used interchangeably with some other terms, and I'm not sure we always understand exactly what each other means when we say it. In your, you call it glossary, or I forget exactly, there's a section in your code that defines terms for the purposes of ULDC. And it says, a subdivision is any piece of property that's been divided more than once. Period. Well, if that's the definition that you go by, then virtually everything in this county is a subdivision. Now, I have brought that up with the planning and zoning people, and they tell me, well, in another section of the code, and I'm not sure if it's in the ULDC, you help me, there's a thing about major subdivisions which has some sort of different, not exactly the same definition. And I think that when we're talking about some of these things, when one of us says subdivisions, we're meaning what the definition in the ULDC means, and other times we're not quite as careful, and when we really mean major subdivision, we don't always say it. My point is, that needs to be very specific, because any code or whatever that just says subdivision and that's all, then that's what it's going to mean within the definitions that you have adopted within that code. So anything that excludes anything based on subdivision per se without some sort of qualifier is extremely restrictive, pretty near prohibitive. So that needs to be addressed so that we don't get where we are right now, if you will, and that we're not quite sure what we really meant at the time. It needs to be specific. That's my whole point. The other one is dealing with homeowners and covenants. I'm going to read the sentence that was in the proposal that was tabled a little while ago and was the basis of my concern about the subject. This is convoluted, okay, so hang on. Personal care homes, in addition, a personal care home shall allow up to 6 adults in all single-family residential zoning districts upon approval of the homeowners association and/or a deed search confirmation from an attorney that the use of the property does not violate any subdivision covenants or regulations. So a homeowners association can pass regulations that exclude people. That sentence empowers that, and that's not acceptable. Do I get a half a dozen of my 9-member association and pass a regulation that county commissioners can't live in my subdivision? And that's insane, obviously. But the whole idea of them being able to do it just on regulation by a group of individuals is obviously not acceptable. Your own county attorney has said they don't enforce covenants, subdivision covenants, and they don't, and they shouldn't. A covenant is an agreement between private individuals. That is your definition. It's in your list of definitions in the Uniform ULCD. I forget exactly what it means. It is a thing between private individuals. So why is the county in it? The fact is, even in the way you have your approval here, you say you got to have either the homeowners association, and if there isn't one, a lawyer say it doesn't violate the covenant. The other side is simply going to say, well, I say it does violate the covenant, and I've got a lawyer that signs a piece of paper that says so. The staff is then going to be presented with 2 pieces of paper from lawyers that say exactly the opposite. That's not an administrative decision to make. That's a judicial decision. And it's because it's a thing between private individuals. If the county is going to get involved in this type of a civil agreement between private parties, which is, again, is your definition, what other one are you going to get involved in? Which other one are you involved in? And is that the right role of government? Thank you.
Thank you. The next citizen that signed up for public comment is Barbara Dixon of 130 Emerald Drive, McDonough. Good morning, Ms. Dixon.
Good morning.
You have 5 minutes.
Okay, it won't take me that long. I want to thank Mr. Holder for bringing up the fine line. I had something already written, and I'm sorry, ma'am, but I cannot hear you and understand you, so to me it was like going around your elbow to get back to your thumb. There is a fine line in this. I sold a lot of real estate in Florida, and I worked with a lot of covenants. I've been on boards, and not in Henry County. But it still comes back to the Fair Housing Act and the Disability Act. And to me, what I'm hearing here is, and what I've been able to hear and understand, is that if a military person came back maimed, and I had a house, I couldn't have it in cotton fields and house this man because it would be against their covenants. I've lived in bigger homes than they have out there, but it sounds to me like the squeaky wheel is getting the oil. And I hope that you all will come back and realize what the law is, make your decision based on that. We have a Supreme Court of this land that I think Henry County needs to adhere to, not only our local government and get up to date, the state government, as well as our national government. But please remember that there are people out there that need these homes. We all can't live high and mighty. Thank you.
Thank you, Ms. Dixon. The next citizen that has signed, I'm sorry, Mr. Holmes.
Tanya, if this is a, if this is a private issue, why are we involved in this? And am I missing something? I know this was heard about 3 or 4 years ago. Am I missing something?
I don't think you all are involved in a private matter per se. I think what you're doing is taking a look at your ordinance to determine what, if any, changes your ordinance as it pertains to the licensing of these type of uses and other uses should take place. You have an absolute right to regulate land use in this county. That is one of your first and foremost charges.
Within the subdivision, we can't override the covenants within the subdivision. So why are we looking at changing any type of ordinance that have to do with subdivision covenants?
I didn't hear changing that to accommodate that. I heard that we're going to look at that, and when staff comes back to make a final recommendation to you all, we will take all of those policy factors that I discussed earlier into account and make a recommendation to you all. And so it ultimately may be the decision of this board not to have that as part of the final decision, or you could, but you're still in the consideration stage at this point.
Madam Chair, can I make a comment real quick
Mr.
before we go? Ms. Dixon made a good comment, Tanya, when you was talking earlier about covenants superseding state and federal law. And I was just trying to remember, I don't know if it was 02 or 01, where people were challenged, where a lot of these senior communities were being developed, when it was age discrimination, where they were saying he had to be 55 and under. That went all the way to the Supreme Court, and I think that was in 2001. I'm not positive. But what they did is they had to go back and modify their own covenants, because their covenant said they had to be 55 or older in order to live in this community. And same thing applies to apartment homes now, which is public, kind of like a public housing facilities. There was a percentage in it, but that did go all the way to the state. And when you look at all the things that you can be discriminated against with housing and personal property rights, I don't know why we're in this too. I wonder, because we've been pulled in to modify some of these things, and some of the stuff I agree with, some of the stuff I don't agree with. So I just want to make that comment.
Well, the Supreme Court has never had, the Supreme Court of the United States nor the Supreme Court of the state of Georgia has never held that local governments can't impose reasonable restrictions on land use and regulations pertaining to land use. As I started out initially saying, it is a balancing act in how far you can go. But I want this board to be clear, you are not prohibited from imposing reasonable regulations concerning land use. And it has been upheld in federal court that the county governments, local governments can impose regulations on the operations of businesses within single-family dwellings. That's something that you all can do, and we currently exercise in the form of regulating home occupation. So I also think it's important to note that for as much as we're hearing the comments concerning these efforts being restrictive or trying to exclude, it's it's equally as important to note that when this first arose, the moratorium, there were mounds of news articles concerning the mistreatment of individuals in these homes, and local governments not knowing where they were, and people being found abandoned, injured, killed, left to their own devices and without any kind of help. So, there's always two sides to a coin, and I understand this is a passionate area that people feel strongly about, but you all are charged with public health, safety, welfare in this county. You're in charge of imposing reasonable rules concerning land use regulations, and staff will bring back to you a recommendation based upon our best efforts to help you in that process.
Mr. Bowman?
There's been a lot said also about the Americans with Disabilities Act, and I believe that there's an awful lot in there that states to the fact that you can't discriminate about renting a property to someone with disabilities. You can't discriminate about selling a piece of property to somebody with disabilities. I don't know that it brings up the fact that you can't, that you have to provide a business in a subdivision so that they can handle Americans with disabilities. And I don't believe that that's quite true, but it does, I've done a lot of work for the federal government, but there's that the Americans with Disabilities Act means you can't discriminate against purchases or them renting a property or doing some other things. So it's a little bit more to it than just throwing that out. It's like I see some of that as a scare tactic. We're just going to throw that out, and it's it's not totally the way that it was presented. So, thank you.
All right, the next citizen that has signed up for public comment is Connie Dodgen of 245 Barnett Road in Hampton. Good morning, Connie. You have 5 minutes.
Hey, how are y'all? I just want to say first, I don't think anybody's using anything as a scare tactic. I as a parent, we have a special needs daughter that's 34. I have MS. My husband is 8 years older than I am. I worry about what's going to happen with her in the future. She grew up in Henry County. She would love to stay in Henry County. It's tough. These kids, and I'll probably start crying, but these young adults, they have no, they did not want to be born this way. This is something I feel like that God gave us Melissa to take care of her. I feel like that special needs parents were chosen by God to give to special parents that would take care of them. And we depend, on, we would love for our county, for her to stay in the county and not have to live anywhere else. And, we are excluded from so many things. I have spent my whole life for 34 years trying so hard to include people with special needs in everything that I do and everything that she does. And, she has been such an inspiration to me to, she loves her life. She loves living here with her friends, with us. And we've reached the point to where, one day we would love for her to be able to stay within the county that she grew up in, stay with her friends, stay in her Special Olympic program, stay in the Henry County programs, and not be excluded from living if there were group homes in subdivisions. And, the thing about, personal care homes, we use the word group homes, and this is personal care homes, and there's such a difference to me, and I know other people and special needs are a different situation, and they're putting this together, and it's almost became like a thing between, the subdivision and the special needs people trying to find a home, with what's going on with cotton fields. And I just feel like, we want safe, regulated homes for our kids. To my knowledge, Henry County hasn't had the situation, where we want to be regulated and we want them to be safe. And, the other flip side of that is, when we talk about the home occupation, the people that have the heart to work with our special needs young adults, to be able to stay with them 24 hours a day, 7 days a week is an impossible thing. And that's the other thing that needs to be looked at, because having to own the home and, the situations that we've been through, the Bouts have done a wonderful job. Bruce, they've had situations where they, had to put them in different counties, and they have fought so hard for this situation. I mean, she spent the whole last, probably 5 years talking to y'all, and y'all, you've heard the different things, and they have worked so hard for this, and they just want a safe, regulated place for their son to be able to go in Henry County, and he should not be excluded. And to me, that is the bottom line. And I know y'all have gotten emails from special needs parents. This is a huge population in Henry County. And the one thing that I believe that Henry County lacks is providing, homes for our special needs kids. And I agree with the, personal care homes with the adults too. My mom and dad, when your parents age, you want them to be in a safe, regulated place, and you want them to be, people that have neighbors. I've talked to so many people, they would say, I would a lot rather have a special needs family, because they are like a family unit living across from me, than the neighbors that I have. They don't cause traffic, they don't drive. They go to their jobs, they're the best employees. These are important citizens, they're voters. They love living in their community, and I want them to be able to stay in their community. And I hope you'll consider that when you read your emails from our parents and listen, and I appreciate your time. Thank you.
Thank you, Connie. The final comment on this item today is from Sandy Murphy of 15 Plantation Drive in Stockbridge. Good morning, Sandy. You have 5 minutes.
Good morning. I've heard a lot of emotional things said here, and I've heard comments made about specifically Cottonfield subdivision. We're a small subdivision trying to protect our property rights, but this does not just affect our subdivision, it affects every subdivision in the county. We have rights. These people are saying, the property owners, homeowners association shouldn't have rights. We bought our house 22 years ago because it was a nice area. We bought it with the covenants in effect. The covenants kept on going. It wasn't just a 10-year period. They were automatically renewed after 20 years, not 10. We just want to protect our investment, just I think as any of you would want to protect your investment. We're asking for fair treatment also. And we're asking for you to change the codes to help protect us. Thank you.
Thank you. All right, and that's all the public comment we had signed up for that particular issue. And as I stated, this will be advertised for a upcoming meeting, and the board at that time will make a decision, I'm assuming. So the question is, do we want to make a motion to extend the moratorium until the next meeting where this item will be heard? And you'll notice on your upcoming meetings and events that we do have a meeting scheduled for an election day, which is August the 21st at 6:30 p.m. What I'd like to ask the board to consider is to cancel that meeting, so we've never had a meeting on the evening of an election, and instead of having a morning meeting on September 4th, to have an evening meeting so that we can have this item heard at an evening meeting where more people are able to attend. So if the board is amenable to that, all I will need is a motion to extend the moratorium to the evening of Tuesday, September 4th, and to change the 9 a.m. meeting to a 6:30 p.m. meeting. Okay, we have a motion by Mr. Bowman, a second by Mr. Holmes. All in favor? Motion carries 5-0. Thank you, Sherry. All right, this time, we're going to move on to the District 5 appointments to the Council on the Aging. That's Exhibit Number 7. And we have 2 nominations, and Commissioner Holmes, since these are your nominees, if you'd like to say something about each one of those before I ask for a motion to approve those.
First of all, I want to say rest in peace to Frances Colmore. She served on the Hidden Valley. She represented District 5 for Senior Services for a number of years, and she represented District 5 very well. I wanted to wait some time before I appointed anybody, just to respect the things that she her contributions to the community. But I think I found a couple of people that will jump right in, and they will represent District 5 well. I think that the rest of the board will find them as great contributors, and I want to move to approve both Jacqueline and Karen to the Senior Services Board for District 5.
For those appointments, is there a second? Second by Mr. Bowman. All in favor? Motion carries 5-0. All right, we're going to move on. County Manager, anything for public session?
No, ma'am.
Ms. County Attorney, anything?
No, ma'am.
All right. Do we have a need for an executive session today?
Just a brief one.
Okay.
A very brief
Commissioner
one.
Stamey doesn't like the word brief. Every time somebody says brief, it becomes a marathon.
Just a brief one, Madam
All
Chair.
right. I'm going to go ahead and call for or announce the upcoming meetings and events, and then I'll ask for the motion to convene into executive session. Okay, we got to do the approval of the minutes first. Does anyone have any additions to make to the May 1st and May 14th meeting minutes? If not, I need a motion to approve those. Motion by Mr. Stamey, second by Mr. Preston. All in favor? Motion carries 5-0. The upcoming meetings and events, Monday, August the 20th at 9 a.m., we have a regular board meeting. August 21st, the 6:30 p.m. meeting has been canceled due to the election. Monday, September 3rd, all county offices will be closed in observance of the Labor Day holiday. Tuesday, September the 4th at 6:30 p.m., and please note that that is a time change, we will have a regular commission meeting. At this time, I need a motion to convene into executive session for purposes of potential or pending litigation, personnel, or land acquisition matters.
So moved.
Motion by Mr. Stamey, second by Mr. Preston. All in favor? Motion carries 5-0. Reconvene into public session. Motion by Mr. Holmes, second by Mr. Preston. All in favor? Motion carries 5-0. I need a motion for approval and an affidavit pertaining to executive session.
So moved.
Motion by Mr. Holder, second by Mr. Bowman. All in favor? Motion carries 5-0. If there's no further business to come before the board, Mr. Holder?
Does the settlement that was discussed earlier need to be voted on?
Yes, sir. We can do it now. I can do it at the next meeting. I didn't know when I would have the paperwork ready, but I can certainly come up and talk about it now if we want to go ahead and get it done.
I'd like to see it done as quickly as possible.
Madam Chairman, there was an agreement to resolve a claim that has been made against the county concerning a road construction project, Explos road construction project that occurred. The claim involves allegations that the construction of that road project caused damage to a tree that was on a property adjacent to the road construction project. So the board has authorized an agreement in exchange for a release of all claims concerning any activities concerning the road construction project, that the county would pay $1,400 for property that's located, the damage for property located at 49 South Bethany Road. The owner is Carol Edwards. It may be others. I'm not sure who else might have an ownership interest in the property, but Carol Edwards is one of the record owners. And with that, if the board would approve and authorize me to draft the settlement documents associated with that particular resolution, I will prepare that accordingly.
I will move to approve, Madam Chair.
All right, we have Mr. Bowman.
And that agreement would relieve Henry County for any and all claims related to the road project now and forever.
Yes, for all claims that have been asserted or could have been asserted or arisen or could have arisen in connection with the road improvement project. Yes, sir.
With that, I second the motion.
Okay, we have a motion and a second, and before I call for the vote, I do want to clarify that this is not for the purchase of property. This is to settle a damage claim brought against the county as it pertains to property being damaged at this particular location during a SPLOST project.
Yes, ma'am. Thank you.
Okay. And with that clarification, if there's no further questions or comments, all in favor of the settlement, motion carries 5-0. Thank you. If there's no further business to come before the board, I'll entertain a motion to adjourn. Motion by Mr. Holmes, second by Mr. Preston. All in favor? Motion carries 5-0. We stand adjourned.